Modern Real Estate Practice, page 33, continued. In subsequent cases, the U.S. Supreme Court has expanded the definition of the term race to include ancestral and ethnic characteristics, including certain physical, cultural, or linguistic traits that are shared by a group with a common national origin. These rulings are significant because discrimination on the basis of race, as it is now defined, allows a complaint to be brought under the provisions of the Civil Rights Act of 1866. In practice, a real estate professional is not obligated to provide ethnic diversity information to homebuyers. At issue in a 2001 case from Ohio, Hanna versus Sibsai Klein Realtors, was whether a real estate professional had the fiduciary duty to 1. Inform a client whether a neighborhood was ethnically diverse, or 2. Direct the client to resources that provide such information. The court concluded that while real estate professionals might choose to provide such information to clients or direct clients to resources about the ethnic diversity of a particular area, the real estate professionals do so at their own risk, and there is no fiduciary duty to do so. The risk, of course, is that the real estate professional might be accused of illegally steering a client to a particular neighborhood based on the racial, ethnic, or other protected characteristics of its residents. Steering is discussed in more detail later. The 1866 Civil Rights Act applies only to racial discrimination, but 1968 also saw passage of Title 8 of the Civil Rights Act of 1968, which we know as the Fair Housing Act. The Fair Housing Act prohibits specific discriminatory practices throughout the real estate industry. Page 34. Fair Housing Act. Title 8 of the Civil Rights Act of 1968, as amended by the Housing and Community Development Act of 1974, and the Fair Housing Amendments Act of 1988 is the Fair Housing Act. It prohibits discrimination in housing based on race, color, national origin, religion, sex, familial status, or disability. The Fair Housing Act also prohibits discrimination against individuals because of their association with persons in the protected classes. The Fair Housing Act originally prohibited discrimination based on race, color, religion, or national origin. The Housing and Community Development Act added sex to the list of protected classes, and the Fair Housing Amendments Act added disability and familial status. For instance, households with children, although an exception will be made for certain housing intended for persons age 55 or older. The amended act also changed the penalties for violations of the law, making them more severe and added the right to seek damages, such as those for non-economic injuries, humiliation, embarrassment, inconvenience, and mental anguish. The Fair Housing Act prohibits discrimination based on race, color, national origin, religion, sex, familial status, or disability. Housing for Older Persons Act, HOPA. In 1995, Congress passed the Housing for Older Persons Act, HOPA, which repealed the requirement that housing intended for those aged 55 or older have significant facilities and services designed for seniors. HOPA still requires that at least 80% of occupied units have one person aged 55 or older living in them. The act prohibits the awarding of monetary damages against those who, in good faith, reasonably believed that property designated as housing for older persons was exempt from familial status provisions of the Fair Housing Act. The Fair Housing Act is administered by the Department of Housing and Urban Development, HUD. The information on fair housing can be found by going to www.hud.gov and entering fair housing in the search box at the top of the page. HUD is established rules and regulations that further interpret the practices affected by the law. In addition, HUD distributes an equal housing opportunity poster. See Figure 3-1, 3.1. The poster declares that the office in which it is displayed promises to adhere to the Fair Housing Act and pledges support for affirmative marketing and advertising programs. In practice, when HUD investigates a real estate broker for discriminatory practices, it may consider failure to prominently display the equal housing opportunity poster in the broker's place of business as evidence of discrimination. If a real estate brokerage is accused of a fair housing violation and has not displayed the poster, the burden of proof may shift from the complainant, the party alleging discrimination, to the broker. This means that the broker would have to prove that there had been no act of discrimination rather than the complainant proving that there had been an act of discrimination. Page 35. Figure 3.1. Equal Opportunity Housing Poster. U.S. Department of Housing and Urban Development. Equal Housing Opportunity. We do business in accordance with the Federal Fair Housing Law, the Fair Housing Amendments Act of 1988. It is illegal to discriminate against any person or because of race, color, religion, sex, handicap, familial status, or national origin in the sale or rental of housing or residential lots, in advertising the sale or rental of housing, in the financing of housing, in the provision of real estate brokerage services, in the appraisal of housing. Blockbusting is also illegal. Anyone who feels he or she has been discriminated against may file a complaint of housing discrimination. U.S. Department of Housing and Urban Development, Assistant Secretary for Fair Housing and Equal Opportunity, Washington, D.C. Page 36. Definitions. HUD's regulations provide specific definitions that clarify the scope of the Fair Housing Act. Dwelling. The regulations define a dwelling as any building or part of a building designed for occupancy as a residence by one or more families. This includes a single-family house, a condominium, a cooperative, and manufactured or other factory-built housing, as well as vacant land on which any of these structures will be built. Family/familial status. A family can be as small as a single individual. Familial status is defined as one or more individuals under age 18 living with a parent or guardian. It also includes a woman who is pregnant and anyone who is in the process of assuming custody of a child under age 18. Housing that qualifies for older people is exempt. Otherwise, single or multi-family housing must be made available to families with children under the same terms and conditions applied to anyone else. It is illegal to advertise properties as being for adults only or to indicate a preference for a certain number of children. Landlords and condominiums cooperatives cannot restrict the number of occupants with the intent of eliminating families with children. Any occupancy standards must be based on objective factors such as sanitation or safety. In practice, an elderly tenant was terminally ill and requested that no children be allowed in the vacant apartment next door because the children's noise would make the situation more difficult. The owner of the apartment building agreed and refused to rent that unit to families with children. Although the intent was to make things easier for a dying tenant, the owner was nonetheless found to have violated the Fair Housing Act by discriminating on the basis of familial status. Disability. A disability is included in the Fair Housing Act as a handicap, although the word disability is now the preferred term. A disability is a physical or mental impairment that substantially limits one or more of a person's major life activities and includes having a record of having such an impairment or being regarded as having such an impairment, even if one does not exist. It is unlawful to discriminate against prospective buyers or tenants on the basis of disability. Persons who have AIDS are protected by fair housing laws under the classification. The classification does not include current illegal use of or addiction to a controlled substance as defined in the Controlled Substances Act. In practice, just as the Federal Fair Housing Act's protection of persons with a disability does not include those who are current users of illegal or controlled substances, it also does not extend to individuals who have been convicted of the illegal manufacture or distribution of controlled substance. The law does prohibit discrimination against those who are participating in addiction recovery programs. For instance, a landlord could lawfully discriminate against a cocaine addict, but not against someone who is in a drug recovery program. Landlords must make reasonable accommodations to existing policies, practices, or services to permit persons with disabilities to have equal enjoyment of the premises. It would be reasonable to expect a landlord to permit a support animal, such as a guide dog, in a normally no pets building, or to provide a designated parking space in a generally unreserved lot for a person with a disability. Page 37. People with disabilities must be permitted to make necessary, reasonable modifications to the premises at their own expense. Such modifications might include lowering door handles or installing bath rails to accommodate a person in a wheelchair. Failure to permit reasonable modification constitutes illegal discrimination. The law recognizes that some reasonable modifications might make a rental property undesirable to the general population. In such a case, the landlord is allowed to require that the property be restored to its previous condition when the lease period ends, aside from reasonable wear and tear, where it is necessary to ensure with reasonable certainty that funds will be available to pay for the restorations at the end of the tenancy. The landlord may negotiate, as part of a restoration agreement, a provision requiring that the tenant pay into an interest-bearing escrow account over a reasonable period, a reasonable amount of money not to exceed the cost of the restorations. The interest in the account accrues to the benefit of the tenant. A landlord may not increase the required security deposit for a person with a disability. However, the law does not prohibit restricting occupancy exclusively to persons with a disability in dwellings that are designed specifically for their accommodation. In a newly constructed multi-family buildings with an elevator and 4 or more units, the public and common areas must be accessible to persons with a disability, and doors and hallways must be wide enough for wheelchairs. The entrance to each unit must be accessible, as well as the light switches, electrical outlets, thermostats, and other environmental controls. A person using a wheelchair should be able to use the kitchen and bathroom. Bathroom walls should be reinforced to accommodate later installation of grab bars. Ground floor units must meet these requirements in buildings that do not have an elevator. Real estate professionals should be aware that state and local laws may have stricter standards. Exceptions to the Fair Housing Act. The Federal Fair Housing Act covers most housing but does not exempt owner-occupied buildings with no more than 4 units, single-family housing sold or rented without the use of a real estate professional, and housing operated by organizations and private clubs that limit occupancy members. The rental of rooms or units in an owner-occupied building of no more than 4 units is exempt from the Fair Housing Act. The sale or rental of a single-family home is exempt from the Fair Housing Act when the transaction meets all the following conditions. The home is owned by an individual who does not own more than 3 such homes at one time, and who does not sell more than one every 2 years. A real estate professional is not involved in the transaction. Discriminatory advertising is not used. Housing owned by a religious organization may be restricted to people of the same religion if membership in the organization is not restricted on the basis of race, color, or national origin. A private club that is not open to the public may restrict the rental or occupancy of lodgings that it owns to its members as long as the page 38. Lodgings are not operated commercially. Membership in a private club must be open to people of all races, colors, and national origins. In practice, the Metropolitan Club accepts members who have graduated from Grandiose University, a private institution. At its building in downtown Metropolis, the club has some sleeping rooms that makes available to members at a nominal cost for more than a 1-week stay every year. Because the rooms are provided as a member convenience and not operated as a commercial venture, their use can be limited to members of the Metropolitan Club. The Fair Housing Act does not require that housing be made available to an individual whose tenancy would constitute a direct threat to the health or safety of other individuals, or who would result in substantial physical damage to the property, of others. Housing for older persons. As mentioned earlier, while the Fair Housing Act protects families with children, the Housing for Older Persons Act, HOPA, provides that certain properties can be restricted to occupancy by older persons. Housing intended for persons aged 62 or older, or housing occupied by at least one person 55 years of age or older per unit, where 80% of the units are occupied by individuals 55 or older, is exempt from the familial status protection. Such senior housing typically will allow temporary occupancy by younger visitors, such as permitting overnight visits for up to 2 weeks per year. Americans with Disabilities Act. Although the Americans with Disabilities Act, ADA, is not a housing law, it still has a significant effect on the real estate industry. ADA requires reasonable accommodations in employment and access to goods, services, and public buildings. The law is important because real estate professionals are often employers, and their offices are public spaces. ADA's goal is to enable individuals with disabilities to become part of the economic and social mainstream of society. Information can be found online at www.ada.gov. Title I of ADA requires that employers, including real estate professionals, make reasonable accommodations that enable an individual with a disability to perform essential job functions. Reasonable accommodations include making the work site accessible, restructuring a job, providing part-time or flexible work schedules, and modifying equipment that is used on the job. The provisions of the ADA apply to any employer with 15 or more employees. Title III of ADA requires that individuals with disabilities have full accessibility to businesses, goods, and public services. As a result, building owners and managers of commercial spaces must be constantly alert to ensure that obstacles are removed. The Americans with Disabilities Act Accessibility Guidelines, ADA-AG, contain detailed specifications for designing parking spaces, curb ramps, elevators, drinking fountains, toilet facilities, and directional signs to ensure maximum accessibility. Unless a real estate professional is a qualified ADA expert, it is best to advise commercial clients to seek the services of an attorney, an architect, or a consultant who specializes in ADA issues. Page 39. In practice, in 1999, the U.S. Supreme Court strictly limited the definition of persons with disabilities protected by the ADA. As a result, ADA excludes individuals whose disability, such as nearsightedness, can be corrected. In 2002, the U.S. Supreme Court narrowed the definition even further by stating that in determining whether a person has a disability, you may ask whether the impairment prevents or restricts the person from performing tasks that are ordinarily of central importance to daily life. ADA and Fair Housing Act. ADA exempts from its requirements property that is covered by the Fair Housing Act, which already prohibits discrimination on a basis of disability, and property that is exempt from coverage by the Fair Housing Act, such as housing for those age 55 or older. Some properties are subject to both laws. For example, in an apartment complex, the rental office is a place of public accommodation. As such, it is covered by ADA and must be accessible to persons with a disability at the owner's expense. Individual rental units would be covered by the Fair Housing Act. A tenant who wished to modify the unit to make it accessible would be responsible for the cost. Issues of housing and disability discrimination are often litigated in the courts. For example, in Wells versus State Manufactured Homes, a 2005 case before the U.S. District Court, District of Maine, the landlord ordered the owner of a manufactured housing unit to move from the community because he claimed she violated the no pets provision of her rental agreement. The landlord refused to make a reasonable accommodation for the owner's emotional disability by permitting her to keep a dog. She filed suit under the ADA and Fair Housing Act. The court held that there was no violation of the Fair Housing Act or the ADA. The court said she failed to establish that her mental impairment substantially limited a major life activity and so did not meet the definition of a disability under ADA. In practice, real estate professionals need a general knowledge of ADA's provisions in dealing with clients and customers. It is necessary for a real estate broker's workplace and employment policies to comply with the law. Amendments to ADA are periodically introduced in the U.S. Congress, and it is important to be aware of changes in the law. Real estate professionals who are building managers must ensure that the properties managed are legally accessible. ADA compliance questions also may arise with regard to a client's property listed for sale or lease. Unless the real estate professional is a qualified ADA expert, it is best to advise commercial clients to seek the services of an attorney, architect, or consultant who specializes in ADA issues.